Hey everyone, I want to do a quick video today just to highlight the two main forms of alternative dispute resolution, or ADR. As I think we've discussed, as you've seen maybe in some of your readings, litigation is really something that you want to think about as an absolute last resort. The good news for us is that today there are numerous forms of ADR. That was not always the case. Many of these, really, it's just been in the last few decades that these have really gotten popular, really kind of taken off and become widely available. Again, today we're going to focus on kind of the two main forms, but there are numerous hybrid forms of ADR. There are totally different types than I even have listed up here. Almost every form of ADR is now available online. So there are a lot of very, very affordable but high quality options that are out there. And many of these can be pursued either as a true alternative to litigation, so before a lawsuit's ever filed, or even after a lawsuit has been filed, the parties may use certain forms of ADR to help them to reach a settlement, and in that way, the case can be dismissed and never actually go to trial. So again, ADR is great. Saves it is generally believed um, to save money in comparison to litigation. There are also some other advantages aside from the cost savings that we will discuss kind of as we go through these. And then the other key thing that is an advantage to ADR is many of these forms are also a lot quicker than the litigation process too. So you're really saving time and money in general with these forms. Okay, so our two major types of ADR, kind of the most popular, widely known, would be mediation and arbitration. And so I've got kind of a comparison up here of some of the key differences between mediation and arbitration. One similarity is that both do involve a third party. So you have either a mediator or an arbitrator, or sometimes a panel of arbitrators who is basically acting almost kind of as a go-between, um, in addition to the parties who have been negotiating and trying to settle the case. Okay, so let's talk about mediation first. Mediation, one big advantage to this is that the outcome is totally voluntary. When you go to mediation, essentially what happens is that you'll meet at a designated place. A lot of mediators are retired judges. Many mediators are actually practicing attorneys. My dad has been practicing law for close to 40 years now, and more in the past few years, he's been dedicating kind of his business to doing mediations. And he actually loves doing mediations because, he feels like he's helping people resolve their differences as opposed to being kind of on one side or the other. So he sort of likes helping people work together. But when he does a mediation, he just has the parties and the attorneys for both sides come to his law office. And a lot of times he'll kind of sit everybody down together in a conference room, kind of talk to everybody about the process and what the plan for the day is. Prior to the mediation, both sides will submit a report to the mediator where they both just kind of outline their case and why they feel like their case is strong, and talk about some of the evidence that they have gathered, so far. And so my dad will have already reviewed all of that. Um, but and he'll have a good idea of the background of the case. He'll be provided with if there's any court documents, he'll usually be provided with copies of those. So he's got a good idea of kind of what the dispute is all about. And so he'll sit everybody down together, talk about the plan, and then separate the parties into different conference rooms. And then the mediator will just kind of go back and forth, and sort of talk things through, and sort of try to work toward bringing the parties together to reach a settlement. So one big thing with mediation, and you kind of may be thinking to yourself, well, how could this possibly be all that effective? I mean, right? What's really the difference between that versus negotiation, which you're doing on your own and without a mediator involved? Well, the key is if you get someone who is kind of known to both parties, respected by both parties, someone with a lot of experience, a lot of times having that neutral person there to really give a critical and honest evaluation of the case, a lot of times that really is what it takes to bring the parties together. I've had other lawyers tell me that sometimes that their own clients don't want to hear kind of the honest truth a lot of times. If there's weaknesses in the case, a lot of times the client reaction is kind of like, well, it's your job to fight for me, right? And sort of that feeling of, well, aren't you on my side? You're supposed to be on my side. So a lot of times, even from a client's own lawyer, it's hard when someone is very, very entrenched in their own position. It's sort of hard to see the other side of things. Well, when you've got that neutral person who's reviewed both sides, has reviewed all the evidence, somebody that has experience in that area of the law, when that person comes to you and says, hey, look, I know you really think that that this is a $100,000 case or whatever, but I really feel like if you go to a jury, you're probably just not going to expect that much as a result. Then that can help to bring either side, whether it's the plaintiff or the defendant, get their expectations a little bit more in line with reality and get them a little bit closer to each other. And so it does facilitate settlements. There have been cases. My dad's talked about cases where the lawyers for both sides said coming in, there's no way this case is going to settle. We've been negotiating for sometimes years, and we don't see any hope at all. And in a day or 2 days, they'll have ended up reaching a settlement. So it really is something that can be very effective. Now, the court, in a case where a lawsuit has been filed, one thing to note is that a court may actually order the parties to try to kind of attempt mediation. Many states give judges the authority to do that. If they think there's a chance of a settlement, judges love when cases settle because that takes them off their docket, and that's less, that the court needs to do in terms of that particular case, and then you can focus on managing the hundreds of other cases that you're dealing with. So judges love it when cases settle. So a lot of times a judge will order the parties to at least attempt mediation. Even if the judge does not do that, mediation can be agreed to by both parties, and that can be either before a lawsuit's ever filed or after a lawsuit has been filed. The parties can always agree to try. However, and jumping back up here to number one of the big advantages to mediation is that the outcome is always voluntary. The mediator is not forcing you into any decision. The mediator may recommend a settlement, may say, here's what I think a fair settlement is. However, you're never going to be forced to accept any recommendation by the mediator. So there's really sort of no downside to trying mediation, even in cases where you don't think the hope of settlement is very high. Yes, there are fees, you do need to pay the mediator for his time, but in the event that you are able to settle it, you're saving a ton of money in legal fees moving forward. You're reaching a settlement that you may not love, but at least both parties can live with. Otherwise, presumably, you wouldn't agree to it. So there's really kind of no downside to trying mediation. Another thing to point out here as far as advantages of mediation, if you have a situation where you've got a dispute with someone, whether it's either a current or a former, it could be some kind of an employment issue. It could be, any kind of a supplier, so an independent contractor that you've worked with over the years. If there's been some ongoing relationship between the two parties in a particular dispute, if you're interested in preserving that relationship moving forward, mediation is a fantastic option. It is a much more collaborative approach, whatever the outcome is. Again, neither party may love it, but both sides can live with it. You have a much better chance of being able to kind of preserve a working relationship moving forward versus if you end up in litigation in court, which is a very adversarial process. It would be very, very, very difficult for there not to be kind of hurt feelings or negativity that would prevent moving forward if a case has to be resolved through litigation. So that's always something to keep in mind. Okay. Turning now to arbitration as our other major form of ADR. In this case, again, you still do have a third party who is um, helping to reach a resolution in the case. So in arbitration, that's usually called an arbitrator, or you may have a panel of arbitrators. Sometimes you'll have a 3 or a 5-person panel in an arbitration. Sometimes it's just one person. Now, the major difference here is that the arbitrator reaches a binding decision. So the outcome is in general going to be a binding order. And down here, if you jump down here, the order that an arbitrator reaches is usually called an award. And that award, for the most part, in most forms of arbitration, is binding. Like I said, there are other forms. There's hybrid forms of mediation and arbitration. So there are some non-binding forms of arbitration that you do hear about, but the majority of the time, when you're hearing people talk about arbitration, they're usually talking about a situation where the arbitrator reaches a decision. There's a hearing, the arbitrator evaluates the evidence. You may have testimony in a way that's kind of similar to a court proceeding, but usually not quite as formal. But you do present evidence, you may have testimony, and the arbitrator is going to evaluate that and then reach a binding decision. Now, because of that, right, because the outcome is going to be binding on the parties, you cannot have a situation where the party, whoops, this is the perils of working from home during a pandemic, as we lose our whiteboard here. All right, I'm just going to hold on to this for the rest of the video today. Okay. So, because arbitration is binding on whatever the decision is, the parties have to agree to pursue arbitration. You would never have a situation where a judge or anybody else can force parties to go to arbitration and then just take whatever award they get. Now, as far as when we say the parties have to agree in advance, that usually happens in one of two ways. A really common way where you see this is in contracts. So many contracts do contain arbitration clauses, and they'll say if there's any dispute between the parties related to this particular contract, the parties are agreeing at the time they sign the contract that they'll resolve any dispute through arbitration instead of through the court system. So you can have an agreement at that time. It's also possible to have a situation where you may not have an arbitration clause, or you may have a dispute that's not even contract related. There's nothing to say that the parties couldn't agree to try arbitration after a dispute actually comes up. I think that would probably be somewhat less common to see. There may be particular industries where you may have that type of an agreement. In international disputes, there are occasions where you may see that happen. I would say in a normal, in a normal tort case, car accident, personal injury case involving like an individual plaintiff, you would be far less likely to see the agreement to pursue arbitration in any of those kinds of cases. Usually when you see kind of consumers or individuals involved in arbitration, it's because they've signed some contract with an arbitration clause. Okay. Now, one thing to note about arbitration is there are some benefits. Arbitration is actually, I would say, the evidence on whether or not this is cheaper is a little bit more mixed. With mediation, you're almost certainly going to save money. With arbitration, I've actually seen some mixed evidence on this. So the perception, especially in the business world, is that arbitration is always cheaper, that it's always more cost effective. There have actually been, though, some fairly recent studies that suggest that's not necessarily the case. So I think that's a little bit more iffy, although the fact does remain that particularly in the corporate world, arbitration is seen as very popular. It is seen as is more advantageous versus litigation. So that's kind of just an interesting point about that. But one downside, no matter what side you're on in arbitration, is that an award in an arbitration is very, very difficult to appeal. There are limited grounds that you can rely on if you want to appeal an arbitration award in court. But the general kind of fairness of the award is really not one of them. You need to be able to show things, something along the lines of the original agreement to go to arbitration was not valid, or that if there was an arbitration clause in a contract, that the clause was for some reason unenforceable. Certain types of fraud are grounds for appeal of an arbitration award, but the grounds are far more narrow for appeal than if you obtained a jury verdict, or if you obtained any other kind of a judgment in court. In court, in general, if you get a decision at the trial court level that you don't like, you can pretty much always, you're virtually always going to be able to find some grounds for appeal, and get at least one level of appeal at the intermediate court level. With an arbitration award, that is absolutely by no means a guarantee. So that is kind of something to consider as you're making that trade-off. Okay? All right, so that sums up sort of our major forms of ADR and some of their key differences, some of their advantages and disadvantages. As a final point, I guess if we kind of had to rank ADR and litigation by sort of formality, which is another consideration just in terms of what the procedures look like, litigation would certainly be the most formal type of process. Arbitration would be a level below that. Mediation would be your kind of least formal form of ADR, and then of course, negotiation, which is kind of a separate thing, but negotiation would be obviously even less formal than mediation, but that would be kind of if we had to rank those. Okay. All right. So that is it for ADR, and hope you all have a wonderful day.